Critical analysis of cybercrime control in Pakistan. Problems in criminal justice response to cybercrime in Pakistan. 1. Lack of investigators in FIA for NR3C. 2. Training and expertise issues. 3. Lack of cybercrime investigation facilities in district FIA offices. 4. Technical and sophisticated nature of cybercrime investigations. 5. Delayed investigation process. 6. Many people usually do not report cybercrime. 7. Technical challenges for investigators. Cybercrime investigators also face technical challenges. For example, numerous digital devices have proprietary operating systems and software that require the use of specialized tools to identify, collect, and preserve digital evidence. What is more, investigators may not have the necessary equipment and digital forensics tools needed to adequately conduct cybercrime investigations involving digital devices. Criminal justice agents, such as prosecutors and judges, also require specialized knowledge of cybercrime and digital forensics. Like law enforcement agencies, the sufficiency of training of prosecutors and judges varies between and even within countries. For example, the Crown Prosecution Service in the United Kingdom is well equipped to prosecute cybercrimes, whereas, as of 2016, prosecutors at the local level did not have the same training and resources to prosecute cybercrime. Likewise, Pakistan also lacks a mechanism for efficient prosecution and trial of cybercrime at the local or district level. 9. Bungled investigation. The existing legal framework in the country primarily addresses the substantive side of the law, which is quintessentially conceptual and abstract. The gaps in the procedural and practical side covering the working of investigative agencies often lead to bungled investigations and, in turn, to failed prosecutions. 10. Issues in reporting of cyber offenses. Before an investigation begins, a cybercrime must be reported. While this seems like a straightforward first step in a cybercrime investigation, the reality is that cybercrime is largely underreported worldwide. The underreporting of crime can be explained by economist Gary Becker's expected utility theory, which holds that people engage in actions when the expected utility, i.e., gains, from these actions are higher than the expected utility of engaging in other actions. Applying this theory to cybercrime, victims of cybercrime will not report cybercrimes if the expected utility from this reporting is low. However, a person or organization's willingness to report cybercrime depends on the type of cybercrime. Existing research identifies several reasons why cybercrime is underreported, including A. The shame and embarrassment associated with being a victim of certain cybercrimes, e.g., romance scams. B. Reputational risks associated with publicizing cybercrime, e.g., if the victim of the cybercrime is a business, loss of consumer confidence. C. Being unaware that victimization occurred. D. Low confidence or expectation that law enforcement can assist them. E. Too much time and effort to report cybercrime. F. Lack of awareness on where to report cybercrime. In reporting cyber offenses, the most critical question from the point of view of a victim is regarding the appropriate forum. It may be noted that in Pakistan, prevention of crime, its detection, and maintenance of public order are provincial concerns. The areas in which the Federation legislates and executes criminal law usually are specific in nature and have extraterritorial jurisdiction and interprovincial impact. Nonetheless, this distinction remains opaque. As a result, there is no singular criminal justice system in the country. In fact, the federal and provincial systems coexist. The Prevention of Electronic Crimes Act 2016, PEK, treats cybercrime as federal offenses. The responsibility to register and investigate crimes, therefore, falls on the federal government. The PCA 2016 provides for extraterritorial jurisdiction and authorizes the federal government to establish or designate a law enforcement agency for the investigation of cybercrime. The law also provides for an enabling provision for the establishment of a Joint Investigation Team, JIT, by the federal or provincial governments, as the case may be, containing an authorized officer. The restriction that only the authorized agency, and within it the authorized officer, can initiate investigation of cybercrime narrows down avenues for victims seeking state help in dealing with cybercrime. 11. Gender-based cybercrime. A report revealed that FIA Lahore received more than 5,500 complaints of cybercrimes in 2018 involving hacking, identity theft, cyberbullying, cyberstalking, financial fraud, digital piracy, intellectual property rights violations, electronic terrorism, and extortion. Most of the harassment cases are reported where females are victims. FIA had established National Response Centers, NRC, aimed at empowering women so that they could raise their voices against online harassment comfortably. However, the NRCs were established only in Karachi, Islamabad, Lahore, Peshawar, Rawalpindi, and Quetta, depriving women in other areas the opportunity to report online harassment. Sources further said that the process of filing online complaints is slow, as 30 to 60 days are usually required to process a complaint, which is why many women avoid reporting their issues. 12. Obstacles in cybercrime investigations. There are several obstacles that may be encountered during cybercrime investigations. One such obstacle is created by the anonymity that information and communication technology affords to users. Anonymization techniques are used for legal and illegal reasons. There are legitimate reasons for wanting to remain anonymous online and maintaining the protection of anonymity online. Anonymity enables individuals to engage in activities without revealing themselves and/or their actions to others. There are several anonymization techniques that cybercriminals use, such as proxy servers. A proxy server is an intermediary server that is used to connect a client computer with a server that the client is requesting resources from. Anonymizers, or anonymous proxy servers, hide users' identity data by masking their IP address and substituting it with a different IP address. 13. World Wide Web, the basics. The most common visualization of the World Wide Web is as an iceberg in the ocean. The part of the iceberg above the surface is known as the surface web, or visible web, or ClearNet. This part of the web includes indexed sites that are accessible and available to the public and can be searched using traditional search engines, such as Google or Bing. The deep web is the part of the iceberg that is below the surface. It includes sites that are not indexed by search engines and are not easily accessible and/or available to the public, such as password-protected sites. These sites can be accessed directly if the Uniform Resource Locator, URL, i.e. website address, is known and/or user credentials, i.e. usernames, passwords, passphrases, etc., are provided to gain access to password-protected websites and online forums. The dark web requires the use of specialized software to access its sites because of its use of anonymity-enhancing tools to obscure access and hide sites. The lack of harmonized national cybercrime laws, international standardization of evidentiary requirements, both in terms of admissibility in a court of law and in terms of international state responsibility, mutual legal assistance on cybercrime matters, and timely collection, preservation, and sharing of digital evidence between countries also serve as obstacles to cybercrime investigations. In regard to certain types of cybercrime, especially cybercrimes that are politically motivated, a general lack of will of countries to cooperate in these cases has been observed.